Chairman Wontumi is in a big trouble. He has been sentenced to 20 years in prison in hard labor. Just prison. Now, I shock a lot of people. Because when we talk about people with political influence, power and connection, Chairman Wontumi, nobody ever knew a day like this would come. We'll check it online now. Majority of Ghanaians are very, very happy. So the reason why he has been sentenced because of his involvement in illegal mining. Yes, some illegal mining, sir, to the state, it is very, very wrong. So for the past few months, in and out of court, and a year the movement. Finally, a few minutes ago, and a sentencing a buyer at the High Court. All this because of his Akunta mining and the illegal mining are occur undertaking within the Samra Boy Township. So before Ibe Jaimono, HSA TV3 reporters, all credit to them, took their time to break down the story. HSA Oshe video now, you would understand from the genesis to the last end and why he was given that sentence.
What are these counts and what are we looking at is what we're seeking to get a bit more in terms of details on for you this afternoon here on the bulletin. And I'm just going to walk you through what the particulars of the offense are, right? And then it will set the tone nicely for us to begin to appreciate, amongst many other things,
very well,
what it is that we're seeing.
We'll give you time. We'll give you time, Mawena, to work on that. But we know that Chairman Wontumi was convicted of assigning mineral rights without approval and purposely facilitating illegal mining at a Samre Boy concession. But Mawena will take us through the rest of the offenses in a tad, because there are about 6 of them. The court found him guilty of all 6. And he's been handed down 20 years in prison with hard labor. That's the latest that's coming on this matter. But what were his offenses in this landmark case? Mawena, what do we know?
And so 6 counts, and there are 3 individuals involved in this particular matter. A number of persons have been asking questions, and I've been seeing people drawing linkages to other cases currently in court.
Right.
This is the Samra Boy case involving Wontumi, which has to do with assigning mining rights to another person without approval by the minister. And on the first count, assignment of mineral rights without approval, contrary to sections 14(1) of, just a moment, a bit of a trick there, but a bit better, right? So, just a moment.
Oh,
so
what a shame.
To section 14(1) and section 99(2)(b) of the Minerals and Mining Act 2006, Act 703, as amended by section 3 of the Minerals and Mining Amendment Act. That is the first count, and that is against Bernard Ntribu-Esiaku, who is one of the directors of Akunta Mining Company. Then there is the second count, right? That has to do with Kwame Entry, who's at large as we speak.
Right.
The third count, just a moment. And so we get to see
So I mean, essentially what you're trying to show us is that there are 3 accused persons here. Chairman Wontumi, one other person called Kwame Entry, and then the company.
And then the company.
Right. And Chairman Wontumi has been convicted of counts
1 and 4.
And 4, right.
Counts 1 and 4, because count 1 directly to him, and then count 4 as well, purposely facilitating an unlicensed mining operation contrary to section 99(2)(b) of the Minerals and Mining Act as amended by section 3. So count 4 as well. Then we see count 5 going to Kwame Entry as well, who's still at large, and then count 6 as well to the mining company. But as company is deemed as a separate legal entity, and so it also is before court. But on counts 1 and then 4, which speaks directly to the person, Bernard Ntribu-Esiaku, we're seeing that 20 years for both counts, 10,000 penalty units for both counts as well, and it's expected to run concurrently as we speak at this particular point in time. And so we see counts.
This is count two.
This is count two. Kwame Entry at large, that you in the year 2024 in Samrabo in the Western region and within the jurisdiction of the court, blah, 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 and blah, permitted mining without approval from the minister. And so that is count two. And then we see counts three in relation to Akunta Mining Company as well and all of that. So 6 counts, 2 each for
Directly.
Wontumi, Kwame Entry, and then Akunta Mining Company. It's just a shame that we've not really been able to go through all of the entire detail. But you see count 6 there, for instance, which deals specifically with Akunta Mining. We see count 5, Kwame Entry, like I was mentioning again, also dealing with facilitating an unlicensed mining operation contrary to Section 99(2)(b) of the Minerals and Mining Act 2006. And this is where we are at this particular point in time. And we've been hearing, we've been seeking to get a bit more in terms of reactions as well. I'm sure we'll go back to the court for our man, Lord Eduasare, to paint a mood for us as well, because there's been a lot said, what the court looked like, what his mood was like when the judge began detailing the count one after the other and was arriving at the guilty conclusion, amongst other things, what he made of it before he was subsequently whisked away by officials of the security service after the court's hearing as well.
Right. I want us to go back to count 1, which is directly related to Chairman Wontumi, because that is when they say he assigned mineral rights without approval. And he was found beyond reasonable doubt that no ministerial permit was obtained, for which reason he was convicted on that as well. And on count 3, Akunta Mining, the company, as you've explained, was also convicted. Of the offense there as well. But let's stay on count 1, right? Because Moena, that is where the bulk of the issue is how Chairman Wontumi is now getting 20 years in prison with hard labor. The judge says, look, when we go through the evidence, we see that there was no ministerial permit for that. What are we seeing on that as far as the charge sheet is concerned? Right.
So going back to that, and we'll get that for viewers pretty shortly as well. Going back to that speaks directly to his concession, right, at the Samraboy Forest area.
Right.
And so he had a concession which was given unto him, which means he could go in and mine in and of himself, but he subsequently resorted to handing it over to a third party. Now, what the requirement of the law is that in proceeding to do something like that, it requires the approval of the Minister for Lands and Natural Resources. That was not done. And so our laws are a bit funny when it comes to engaging in illegal mining. So you can have permits, all right, but when you breach, you enter the realms of illegal mining. Because as far as you have permits and you're mining within 100 meters of a river body, the law is very specific. It says that even if you have a permit, don't go 100 meters to a river body. If you do that, that becomes illegal mining. And so of the many things which could stray outside of having a legal concession is having a concession and granting permits for someone to mine without the approval of the minister. That's the first count upon which he's been convicted, and is to serve 20 years in hard labor with a fine of some 10,000 penalty units as well.
What do we do going from here? Better rephrase. What does Chairman Wontumi do going from here? Counsel, do I have your permission to engage you? And you have been part of the process. Yes, you have followed the process from day one. You in the thinking of the defense from day one. Is this what was expected?
Certainly not. We are extremely disappointed in the outcome. In as much as we respect the decision of the courts, we have our resentment to the outcome of the trial so far. And indeed, I must say that
You said the outcome of?
the outcome of the trial,
Okay.
having culminated into a conviction and sentencing, because under normal circumstances, one would have thought that at least once a person is charged with assignment of mineral right without authorization, it was right that the Lands Act clearly defines what assignment is. An assignment is by way of a written instrument, and if there was none throughout the trial, and that a person could be convicted and sentenced on same, then it's really a worrying trend. And what can we do except to consult our clients and fashion out the way forward and come out?
But the charges were brought under the Mining Act, right?
Yes, certainly it was brought under the Mining Act, but the Mining Act doesn't talk of assignment. It talks in terms of assignment. The specific legislation that regulates the conduct of land transactions is the Lands Act of 2020. Yes, Act 1036. It regulates the conduct of land transactions. So if you want to really understand what assignment means as far as land transactions are concerned, then you have to go to the Lands Act. And clearly the Lands Act talks of assignment to be a written instrument, but we did not see same. And instead, clearly, once he has been convicted on assignment without mineral rights authorization, it's clearly mind-boggling, and I am not comfortable with the set.
You describe this as mind-boggling. To you, it is unfair. But let's talk about the processes of the trial itself. Would you say due process was followed?
I will reserve some for.
So, Adolfo, Chairman Wontumi, and in 20 years, I shock a lot of people. I'm not going to lie. I shock a lot of people. But wow, Shemi, what do you have to say? Please let me know under the comment section. If you have anything saying, let me know. Vimbas TV so, and do you think a hash or you think he deserves it? Adolfo, we share a video to this point. Say God bless. Don't forget to like, share, subscribe to our YouTube channel. Yeah, that's CP.
Vimbas TV.